wanted, and I still want, of course, was to give you an overview of the legal structure and framework when it comes to the return of cultural objects. Now, friends kept calling me the last day saying, how nice are you going to talk about the Parthenon marbles? We always wanted to know about the Parthenon marbles. Other friends started sending me information on Parthenon marbles, and I didn't intend to speak about the Parthenon marbles. Then we spoke with John yesterday and said, everybody's waiting about the Parthenon marbles. So yesterday evening I sat down and restructured everything. Yes, I'm going to talk about the Parthenon marbles. So my speech today is going to, there are going to be 4 parts. The first part is I'm going to show you the whole legal structure of cultural heritage law and to explain that the return of cultural objects is just a tiny bit of it. The second part will be the most difficult one. I'm going to confront you with the 4 main issues that the lawyer has to deal with when it comes to cases of cultural heritage law. The third part then, we will go a bit back to the first. Once you will have the basic knowledge, I will give you a quick overview of the main legal instruments. And then at part 4, the last one, we are going to combine all 3. I'm going to explain you the huge difference between the so-called old cases and the recent cases. And then we're going to talk about the Parthenon marbles. So off we are. Part 1. The legal jungle. I'm terribly sorry about these colors. It's much more beautiful and elegant on the computer. I don't know, it's a bit dead here, but it's okay, we have to live with that. So how are we going to find our way through the cultural heritage law, which is a huge field, a relatively new field, but a huge field. Cultural heritage is the umbrella term. There is no definition for what cultural heritage law is, and you can find books on that, and we are not going into that. We are going to follow the line of UNESCO, what UNESCO says, because UNESCO is the basis for all legal instruments. Cultural heritage law, we distinguish, when it comes to cultural heritage law, we distinguish first of all between intangible cultural heritage, which is music, drama, songs, or tangible cultural heritage, which is cultural objects, which is cultural property. Now, cultural objects and cultural property, you're going to see both termini quite often. They mean exactly the same. There is no difference. It's just that in the last years there's a shift from the term cultural property towards the term cultural object. Why? Because cultural property implies a bit an economic value. It implies exploration rights, and the international community wants to move away from that. So we are going to use the terminus cultural object. Usually, when you hear people using too much the terminus cultural property, they will be in the field, most probably in the field of trade, of art trade. Once we have decided that we are going to talk about cultural objects, we have to do the next division, which is immovable, the whole Parthenon, not the marbles, the whole Parthenon. We are not going to deal with this today. And the movable, little things that you can remove from one country and take to the other, and then you have to ask them back. Another distinction. Once we have decided we're dealing with cultural heritage, with cultural objects, with movable cultural objects, you have to ask yourself, do we find ourselves in times of peace or in time of war? Because there are totally different legal grounds and laws applying for cultural objects that left the country of origin when there was an occupation, when there was war, and totally different legal instruments when we are protecting our cultural objects in times of peace. I won't spare you, there's one more division. Once we decided that we have cultural heritage, cultural object, movable, protection in time of peace, you have to ask yourself, I've got this cultural piece. How do I want to protect it? Do I want to protect it from destruction, decay, or neglect? Someone is not taking care of it. We are not dealing with that today. Or against illicit export and removal. That we are going to deal with that. And now, the last one. Once we have decided that we're going to deal with these issues, I want you to keep in mind, and this is the most important information of part A of this lecture, that we have to move on 3 levels. First, public international law, which is the relationship between countries, very easily said, between countries. European Union law, when 2 parties are members of the European Union. And national legislation, which is at the end of the day the most difficult and the most important one. With this we have to deal, mainly when it comes to practical matters. In the public international law, I want you to remember the 2 UNESCO conventions, the one UNESCO convention from 1970 and the 1995 UNIDROIT convention. It's called UNIDROIT because the organization who drafted it was called UNIDROIT, for private, international private law, but it's UNESCO behind it. European law, you don't have to remember the numbers, we'll come back to that. So that's the overview. You can see it's a huge field. We only deal with the small parts, and when we deal with that on 3 levels, international law, international public law, European Union law, and national legislation. Part B, which is the most difficult one. A lawyer that will have to deal with a case of return of cultural objects will have to face 4 main problems. The one is ownership. You have, first of all, in order to ask for someone to give you something back, you have to prove that it's yours. Sounds very, very simple. It's not. Especially with antiquities, it can be very difficult. Secondly, you have to deal with a very difficult issue of purchase, of the purchaser in good faith. It's usually, you don't have the owner of the object, the one who stole it, and you're asking for it back. Usually, the usual cases is the one who stole it or illicitly exported it have sold it to somebody. And if this somebody was in good faith, he believed that it was right, that he's really the owner and it was in good right to purchase it, then the initial owner might lose its ownership. The third issue is a choice of law jurisdiction. Which law to apply, which country to apply. Now imagine we have an Attic vase, which was produced in Attica, 5th century. It was exported to Italy in the 3rd century BC. It was illicitly excavated in the 60s. It was sent to, let's say, Switzerland. It was then, Swiss representative laughing, it was then sold in Switzerland, sent to London, auctioned in London. It was bought by someone in Hong Kong, and after he received it, he went to his home and decorated his home in China. Now, which law do you apply? Which court do you address? Very tricky. And it's a field where lawyers like to play, because depending on how you can move things, you can, the whole case, I will show it to you later, the whole case might change. And the last one, which is very close to the third, is the statute of limitation. You might be right, you might be the owner, everything might be on your side, but you might be too late. You can't ask for it anymore. Ownership, which seems easy. Back in 1995, the biggest, let's say the case, the most known case, which explains why ownership is so important. 1995. Italian and Swiss police raided in Geneva, in Freeport, a Medici case exactly, raided a warehouse, belonged to that's better, isn't it? Yes. Belonged to a dealer called Medici, dealer, whatever you want to call it, Medici. And they found thousands, I'm not exaggerating, thousands of antiquities in the warehouse. Now, they didn't only find the antiquities, but they found something else, which makes this case unique. Medici was a very meticulous salesman, so he kept track of everything he did. So we found a lot of Polaroid pictures of all pieces when they were still in the earth, not yet in the proceedings of being illegally excavated, and he nicely wrote below the Polaroid, 1971, Etruscan, for instance, tomb, area of outside of Rome, whatever. Then he continued, he took more pictures after it was cleaned and ready to be sold, again, with all the details who did it and why and whatever, and for what the price is. So what is so special about that? Italy could claim a lot of pieces. Why? Because we had a proof of ownership. It was written. He himself wrote it down that it was from Italy, so it was not a problem. Italy said, look, this is mine, and could take it back. The most famous piece coming out from this case is the Fronius crater, which was returned from the Met Metropolitan Museum in 2006. Medici was sentenced to 10 years of prison and a fine of 10 million euro. And although he addressed all the Court of Appeals, he didn't achieve anything. Now, it's not so easy as you can imagine. I'm going to show you another case, the Sevsko treasure, where the ownership could not be proven. What was that? It was in 1989. A very rich lady went to Christie's, I think, I don't know, one of them, and wanted to sell this collection of silver plates and Roman silver plates. The auction house made a catalogue and published it. Lebanon saw that and said, "Oi, that's ours." And filed claim. But it was not only Lebanon who did the same. Croatia saw that and said, no, that's ours. And filed the claim as well. But it doesn't stop here. Hungary did the same. So Lebanon pulled back last minute, and the High Court of New York, I think, was dismissed, of course, their claims because you couldn't prove who's the owners if the countries can't prove it, really. So the case was lost. And another case, which is pending and very interesting, is the Victorious Youth. It's a beautiful statue attributed to Lysippos, which belongs now to the, careful. It's at the Getty Museum. It was found 1964 outside Fano in Italy, but in the water. So Italy, all these cases are much more complicated, of course, so I'm taking only the part I want to make you clear, make you understand the problems. Italy goes to Getty and said, look, this was found in Italy, outside in our waters, so we give it back to us. And what does Getty say? It was found in the waters, true, but it was international waters. Now, it's a pending case. If whatever side manages to prove where exactly it was found, either international waters or in Italian waters, then they will most probably win the case. We have the other three problems, but this is the main problem of the case. Good faith, very difficult. As I told you before, usually the cultural object is being either stolen or illicitly exported and then sold to somebody. This somebody could, when he bought it, be in very good faith. Maybe he asked where it comes from, he knew the buyer, or he asked for provenance and faked, but very well faked provenance. He got it. Depending in which country this happens, the original owner might lose its ownership. Why? Because of good faith regulations. Common law countries like United States, where our students are coming from. In these countries, the thief can never convey good title, can practically never sell, never make the purchaser owner. They have time of limitations, you can stop it in other ways. But good faith does not apply there, generally speaking. In civil law countries, like in Europe, Germany, Greece, most of the European countries, a thief can transfer ownership. Which means, if I'm in good faith, you're giving me that, you stole it, you give me that, I'm in good faith, I might become owner. Now, either directly, like in Italy, or even in Greece, if you buy it in an open public auction, or after a period of time, like in Germany, it takes 10 years. You buy it, and after 10 years, you become the owner. Now, the good faith issue it's a huge problem and a quite complicated one. Good faith is often presumed. If you can't prove it, you can imagine that it's very difficult to prove when someone was in good faith. Very delicate issue. So often it's presumed, and the burden of proof lies with the initial owner, with the party claiming the object back, which makes it extremely difficult. So the owner who wants a cultural object back has to prove two things, first of all. First, that he is really an owner, and secondly, that the person who possesses it now didn't get it in good faith, or in a country where good faith regulation apply, and did not, so therefore did not become a lawyer. Did not become an owner. Third and fourth issue are very legal, are not so practical, but very important. And these are number 3, especially. You can, as I told you, can play around a bit. Conflict of law, or private international law, or choice of law, whatever you want, it's the same thing. It's a set of rules which practically tell you which law is applicable and which court you will have to address. There are 3 branches, as I told you. I'm sorry, let's for that. 3 branches. First, which law. Secondly, which court. And then the third, which we are not going into today because it's very specific to the country you are talking to, is enforcement. So once you have a court decision, is it possible to enforce it in another country? If we talk about which law is applicable, we have a general rule called lex situs, which says practically that the law that is applicable is the law of the country where the object is, or the last transaction took place. Now, in legal terms, unfortunately, a cultural object is still an object. So if you are asking for the return of a car or the return of a cultural object, I'm exaggerating now, it's the same thing. That's why we apply the general rule of lex situs, the place where it's not. There is, though, a tendency, unfortunately or fortunately, whatever, it's still a tendency to change this and to apply only for cultural objects the lex origin, which means the law of the country that the piece originates from. This is very difficult. In practical terms, it's hardly ever applied because, first of all, it's not always clear, the law of origin, and it's not easy to apply it. But it's a tendency, and it's an interesting idea. And I will show you later on in a case what difference that could have made. When it comes to which court to address, it's usually the court where the object, where the defendant is, where the object is, where the defendant is. So, let me go to number 4, and then with the case I will explain you. Number 4, statute of limitations, is very close to number 3, because depending on which law is applicable, you will see what the statute of limitation is. What is the statute of limitation? It's practically a law that bears claims after a specific period. If you are too late, you are too late. You lost your right, simply speaking. Why do we have such a thing? All legal systems have that, because one day you have to have sort of security, a legal security. You cannot leave things open for such a long time. In civil case, statute of limitation means that there's a time limit until when you can sue someone. And in criminal case, it's limiting time for prosecution of crimes. That was the problem why Marian True was where the criminal charges were dismissed in the Marian True case because of the statute of limitation. In Greece it would have been 15 years, in the United States 3 years. To make number 3 and 4, which are very legal, a bit clear, I'm giving you a case, Berendt against Iran. Denise Berendt was a lovely French lady who I don't remember, it was 35 years ago before the trial. She bought this really beautiful piece, kept it in her flat in France, and then she decided one day that she needs money. So she sent the piece to London, to an auction house, I think it was Christie's, and gave it out for sale. Christie's published it. Iran saw that and said, oops. And addressed the British courts. Why British courts? Because the piece is in England. That's relatively straightforward. So the British courts had to decide now if they are going to apply French law. Why? Because the piece was bought in France originally. The last transaction was in France. Or Iranian law. Why? Because it originated from Iran. If it was Iranian, it was also a problem, but we're not going into that. At the end, it came to this question. The court decided that it has to apply French law. What happened? French law, statute of limitation, 30 years. The lady had it 35 years. Dismissed. She could keep it. If it would have been Iranian law, statute of limitation would have not been applicable, would not apply at all, so it could have sent back to Iran. So you see how a little legal fact can change things totally. And here, lex situs and lex originis. If we would have applied the law of the country where it really came from, again, it could have been returned. So that was section B of the lecture, where I want you to remember the 4 things. When you read something about a case of return of cultural objects, 4 questions. Is he the owner? Is there any purchase of good faith? What law is applicable? Which courts to address? And do we have a case of statute of limitations? Now that you have that in mind, I'm going to give you a very brief overview of the main legal instruments. You remember section A, international public law, EU law, and national legislation. International public law, we have 2 conventions. Please remember just the yes. Yes, we have 2 conventions straight away. One is Convention from UNESCO Convention 1970 and one UNIDROIT 95. I want you to remember this. Don't remember the regulation of the EU. Forget that. You don't have to remember the numbers, but please remember UNESCO 70, UNIDROIT 95, because you're going to see it very often. I want you to know what it is. UNESCO Convention 1970. It was drafted 1970, of course. 182 state parties. Huge convention. It aims to the protection of cultural objects from illicit trade and illegal removal. It regulates prevention and recovery. There are some weak points on this convention. The main weak point is that it's not self-executing. What does it mean? It means that you cannot go to court and say, look, the state has signed this convention, that's why give me my cultural object back. The convention practically says to the countries that are parties, look, illicit traffic of antiquities and removal is not a good thing. So please change your national legislation in that way that you fight it and that prevent it. So each and every country goes back to its national legislation and adjusts it to the ideas of this convention. It's made an instrument of diplomacy, is another big point of it. It means that it applies from country to country, and individual cannot go to court and say, look, because of 1970 convention, I want my cultural object back. This is also a weak point. And another weak point is that it mainly speaks about preventive measures. It doesn't really go deep into the recovery issues. But it's still a very, very important convention. Why? Because it changed the whole mentality, the whole way of thinking. It's at a cut-off date. 1970 is a cut-off day when it comes to the return of cultural objects. most, if not all legal instruments that deal with this issue, they distinguish between cultural objects that left the country of origin before 1970 or after 1970, EU regulations, recommendations, the American Museums Association, they all use this cut-off date 1970. And since then, antiquities that are on the market with no provenance have practically no value. Nobody is going to buy, nobody's serious, would buy an antiquity that has no provenance, that came into the market after 1970 has no provenance. No one would do it. It's suicide. The prices went down. So, a 1970 convention is there for only for that, for other reasons too, but for this reason, very important. But UNESCO, of course, understood that there is a lack, that this is not enough. So what did they do? They went to UNIDROIT, which is it's an organization, UNESCO organization that deals. Does it belong to UNESCO? No. It's an organization that deals with international private law. And they went there and said, look, we have a problem. We cannot really apply this convention. Could you please help us? So they drafted a new convention, which we call 1995 UNIDROIT Convention. This convention, it's a very interesting convention. Down the bottom line, what it does is it protects the original owner. It focuses much more on the recovery phase. It distinguishes clearly between stolen pieces and illegally exported cultural objects. It's a different way of claiming them back. It provides private individuals with the right to go and ask for the cultural objects back. And if we go to the 4 problems we had, first, ownership. They can't do much, the convention can't do much with the ownership, but it declared unexcavated antiquities that are suddenly on the market, that you can call them stolen. So this is something they did on that level. The second problem is good faith. There they did quite a good thing, because they tried to give, we can't say a definition of good faith, there is no definition of due diligence, but they gave some standards that if you follow them, you can claim that someone is in good faith, a good faith purchaser or not.